Families, they can be the greatest source of joy and support in your life. They can also, because emotions are so tied to you and your relationship with your family, can be the source of the greatest stress and grief. That's never more obvious than when a loved one passes away. If you think about families during the happiest times, let's just say Thanksgiving dinners. Everybody's together. Everybody's having a great time. It is a great occasion throughout the whole holiday season. You probably have a story about a conflict that happened at the table or in the kitchen where two family members, maybe you, maybe somebody else, were arguing about something that seems insignificant now or something that seems really significant now. Either way, those emotions and frustrations are heightened because of the familial relationships. I joke with my friends who practice divorce law. Now, my friends that do divorce law, they like to say they're in family law. And I say, well, you're actually in anti-family law, aren't you? I'm in family law because I do only estate planning. And estate planning is really all about making sure that we take care of administrative things so that families aren't frustrated and find other friction points when grief and crisis occurs. This is never more important than when a loved one dies. In this episode, we're going to talk about being prepared, not for somebody passing away. You can never really be ready for that. But then when somebody has passed away in your family and it's time to go see the attorney, to figure out how are we going to get through this process, whether it's probate or trust administration. We're going to talk about how to be prepared for that meeting, hopefully to make you a little bit less anxious about it and to give you some guidelines so you feel as if you're being effective even when emotions are overriding your ability to think as clearly as you might. We're going to break our conversation today into 3 areas to be prepared in. One is the people involved. The second is the documents that are required and are going to be involved. And the third are the assets, the property that was owned by the deceased person. Let's talk estate planning. It's my podcast all about estate planning because I believe in a world, I dream of a world where all families have their estate planning in place so that when grief, crisis, and transitions occur, fights don't break out over friction points that we could have smoothed off on the way. My name's Jim Miskell. I've been practicing law in the state of Georgia for more than 30 years. And in this episode of the podcast, we're going to talk about being prepared and what to expect in that initial consultation with an attorney, whether it's a probate administration or trust administration, whether it's an estate administration, but how to be ready for that and hopefully make you a little bit less anxious about that and feel better prepared. As always, I would like to remind you that what we talk about on the podcast is not legal advice. Legal advice happens when you are sitting down one-on-one with an attorney who asks you a bunch of questions, because to give good legal advice, the details really matter. You can't just kind of do a drive-by and say, here's my problem, how to fix it. Lawyers, they're going to ask a lot of questions. And that's when legal advice is happening. When you have a relationship with an attorney, you've hired them to consult on your situation, and they've asked you all those questions because those details matter. If you ask most attorneys, most questions, most times, the first words that are going to come out of their mouth are, it depends. And it depends based on some details that you haven't told them yet. And that's where all the questions come in. So, a reminder, the podcast is for informational purposes, educational purposes, hopefully a little bit of entertainment, and to give you a good context for estate planning. So when these things arise in you and your family's life, you'll have some idea what's going on. So let's get to it. How to prepare for that initial consultation and what to expect when you meet with an attorney about the death of a loved one. The Let's Talk Estate Planning podcast is available on YouTube and wherever you get your podcasts. If you find the information valuable, if you enjoy it, get something out of it, hit like and subscribe. If you found us on YouTube and you like the material, but you're just tired of seeing me, go subscribe to the podcast on an audio-only format. If you're on audio only and you want to see what I look like, go on over to YouTube and you'll find us there. Either way, we appreciate you being here to get what I consider to be really important information that can be very, very helpful to families. Today, of course, we're talking about how to be prepared to meet with that probate attorney, what to expect in that meeting, and how to be prepared. Three broad categories are going to be topics of conversation in most of those conversations. And the first category is people. And when I say people, we're going to talk about the decedent. That's the fancy lawyer name for the person who died. The other two categories of people you're going to be talking about when you meet with the attorney is who the heirs are and who the beneficiaries are. And the beneficiaries usually people, but could be institutions or charities or something like that as well. But we'll put all that in the category of people. So one, be prepared to discuss who the people are, who the players are in this. Second, the assets of your deceased loved one. Assets also break into three categories, and that's accounts that may be retirement accounts or bank accounts or any sort of financial account. The second being real estate. Usually the home that folks live in, a lot of folks, that's the only real estate they own, but there may be other real estate in the state that you live in, or there could be real estate in another state. So it's important just to be aware of that. And then the third category is tangible personal property. So in that second category, people, then assets. In the category of assets, it's going to be the accounts, the financial accounts, the real estate, and tangible personal property. And third category, again, we're going to break this into three categories, documents. And the documents that are going to be important here are estate planning documents. Is there a will? Can you find it? Can you find evidence that there was a will, but you can't find it? That happens sometimes. That's not altogether uncommon. Beyond that, it's important to as you're looking through file cabinets and safes and fireboxes and those sorts of things, a lot of times it's not obvious what is and isn't an original, what may be part of the will, may be part of a power of attorney, may be part of a health care power of attorney. My best advice is just sort of gather all that up and bring it with you. And then second, death certificates. So estate planning documents, death certificates, just sort of proof of death, because that's going to be something that's important for the court filings. And then third, there can be other court documents involved. And what am I talking about there? There might be marriage certificates, divorce decrees. There might also be a prenup agreement. There might be divorce settlements, all sorts of things that may become important as the process goes on. On a personal note, I can identify with what folks are going through when they're the personal representative for an estate. Several years ago, I ended up as executor for one of my mother's sister's estate, my Aunt Mary. And best thing I ever did was hire a local attorney in Indiana where she passed away. Because I do this all the time in Georgia, and I'm very familiar here, but things work slightly differently in different states. Also, it's different being in the attorney seat and being in the executor seat. Consulting with that local attorney, he was able to help me organize the tasks, what needed to be attended to very quickly, what could wait, what was he going to worry about so I didn't have to, and what was the order that I should attack the other things so that I didn't worry about it. So having him in my corner helped me to realize that somebody else had an eye on the administrative things. I only needed to worry about what I needed to worry about. And in fact, I was able to stop worrying and sleep well at night because I knew that we'd put into place a good plan to get through the process. The court system can move with fits and starts. It's not always predictable as how quickly things are going to get through. There can be little odd factual facets of each case that make them run different than the norm. That's why it's important to have good experienced counsel to guide you through the process. When we talk about being prepared to talk about the people involved, start first with the decedent. You may know him or her by a nickname. My name's James. People, though, call me Jim uniformly. My legal name is James, so it's important to know that kind of thing. This is where a copy of the driver's license of your deceased relative can be really important if you can have access to that. Birth certificates, those sorts of things, just to make sure that you know the proper spelling and proper name. We'll also touch later on court documents that with folks that have been married and divorced, sometimes ascertaining what the proper name is important. So you'll get that from divorce decrees, those sorts of things. Driver's license, passports, those sorts of things are great resources to make sure that you've got the deceased relative's name spelled correctly, that you're calling them what you should be calling them in the documents. Second category of folks you're going to want to be prepared on is the family, because from the family, from the relatives, come the heirs. As we've talked about in other episodes, and as I talk about all the time with clients and in my workshop, heirs are not who are named to get the property in a will. Heirs are the people who inherit under the code, under the state statute, if there isn't a valid will. They tend to come from the family, and it's usually the idea of the nearest heirs. In Georgia, it's spouse and kids. If there's no spouse and kids, then you want to go to parents, or parents still living. If the parents aren't living, then it's, do you have brothers and sisters? If no brothers and sisters, then it's aunts and uncles. And in that idea of brothers and sisters and aunts and uncles is also kids, offspring of deceased aunts and uncles, or offspring of deceased brothers and sisters. So you don't have to understand exactly how it's all going to play out in the code in your state. Let the lawyer figure that out. But one of the things you're going to be talking about with that attorney is who are the family members? Did the deceased person have siblings? Did they have kids? Usually if there's spouse or kids, that's going to be the end of the inquiry there. It gets a little trickier if there aren't easily identifiable local family members. I do have some folks who come and say, well, I don't have any, when we're doing planning, they say, I don't have any heirs. I don't have any family. Not so. Everybody's got some family. It may be distant relatives. But when it comes to working through a court process to either probate a will or to administer an estate, the state needs to know, the judge needs to know who those people are. So it might be a third cousin twice removed, but you got to find those people. When that information is not readily available, that's when Google searches and all that kind of thing can come in. If you can't figure it out yourself, there are investigative firms. It's kind of similar to doing skip traces in other kind of processes, but that can ascertain who the family members are. Because there's been so much work done in the last few years on ancestry and genealogy, a lot of records are more available than they used to be. Census records and those sorts of things can answer these questions. Don't stress out over this, though. You just want to give the attorney an idea of what you know about and where the gaps are, and let them sort of organize what more information do we need. Are you going to be able to provide it? Is their office going to do it? Are they going to need a third-party investigator to figure all this out? So that's the second group. We know who the deceased person is. We know who the family members are. The third group are beneficiaries. This is important if there's a will or a trust. If there is neither a will nor a trust, that second category of family members is going to answer everything we need to know here, and that's who inherits if there's no planning in place, if there's no will or valid will or trust. Beneficiaries are folks who are named in a will or a trust, and they can be people. Normally they're people, but it could be the animal shelter. It could be the Humane Society. It could be St. Jude. It could be mom's favorite charity. So it's important just to get a list. Why? Because in a lot of states, they're going to be necessary for the court process to clear the estate at the end to say, I was promised this under the will, and in fact, I received it. We're in good shape. So all these three categories are important. Hey, Jim Miskell here. Sorry to interrupt the episode. Hope you're enjoying today's content. A lot of times when folks are thinking about this kind of thing, questions spring to mind. If you have questions, we like to do some question and answer episodes. So you can go to our website, letstalkestatesplanning.com, and shoot us a message and say, hey, on the podcast, I'd like Jim to cover this on the next question and answer session. Or if it's hitting closer home, especially if you're a Georgia resident, of course, we can't give legal advice on the podcast because it's not specific for your situation. But if you got a situation that you need to handle, it's important to get that done. So letstalkestateplanning.com is how to contact the office. I'd love to talk with you about the specifics of your situation and make sure your estate plan is everything that your family should have it be. In the meantime, we're going to go back to the episode. Thanks for tuning in, and I hope to talk to you soon. Once you've established the cast of characters, the people involved, the next area to pay some attention to is assets. Now, we all have various kinds of assets, and your loved one who's deceased, there may be bank accounts, brokerage accounts, could be IRAs, 401ks, might be bonds, could be real estate. That might be the house they live in. It could be rental properties, could be other land, could be vacation homes. Also, all their tangible personal property. That includes precious metals, that includes artworks, that includes the Christmas ornaments, that includes the tchotchkes and the furniture. Making sure you've got a good idea of everything that's involved is going to be part of the task of being personal representative or executor or successor trustee as far as you're marshaling these assets to begin to organize them and then to begin distribution. The accounts. Well, if you're very lucky, your loved one has left you a nice organized list with the will in their estate planning binder with all their documents very conveniently organized. This is often not the case with folks I meet with. And so now it requires a little bit of detective work. That's where you're going to the firebox. You're going to the family file cabinet, to the desk in the family office. You're looking for account statements, those sorts of things. A really useful way to run down some of the accounts can be last year's tax returns, because you can track back the 1099s will register each account that had some income last year, and that's a good way at least to get a running start at these things. Real estate, there's the home they live in, and that one's probably pretty easy. Vacation homes, you're going to have to look in another state. You may or may not find copies of the deeds. Very often folks don't have copies of the deeds real handy at home. All that stuff is public record, however. You don't need to collect all that before you meet with the attorney, but it is a good idea to just have a list of what property that you believe is in the estate. And of course, the tangible personal property, easy for me to say, tangible personal property. Again, if you're really fortunate, you're going to find a list that says, I want the painting over the sofa to go to my best friend, Barb. I want my loving niece and nephew to divide the Hummel figurines. Whatever it may be, you'll find a nice list. Very often not the case. Again, it's important at the beginning stages of estates just to kind of find out what you got there. And you don't have to come into the consultation with a complete inventory, but you should begin to think about what's going to be involved here to get your arms around all that property, because most folks have multiple types of property. So those are your assets. That's going to be the next conversation you have in the consultation to organize the estate. You've discussed who the people are, how to identify them, the assets, how to identify those, where they are, what's going to be necessary there, and then finally, documents. So what am I talking about here? Estate planning documents. Again, if you're very fortunate, you're going to find that very organized estate planning document folio or binder or a good file folder with all that stuff in it. But very often not the case. When you do go looking for estate planning documents and you're gathering things up to take with you to the initial consultation with an attorney, I would urge you that more is less. No, that's not right. Less is more? No, more is more. Gather up all the stuff. Sometimes folks are a little disorganized, and you might find that powers of attorney are mixed up with the wills or mixed up with the healthcare directives. I've seen many folks bring in what they believe to be originals that were actually copies given to them by the prior attorney of the estate planning documents that aren't actually executed. So it's important just to gather up whatever you've got, take it with you, let the attorney look through and see if the important documents are all there, and if not, where to go next. If the original isn't present, a lot of times we'll track back to, if there was an attorney involved, we'll track back to the original attorney. Very often they're storing originals in their records, so that's an easy thing to do. Sometimes you find a copy at home. You've got the safety deposit box that you may or may not have access to. If you don't have access to it, Very often the safety deposit box can contain an original will, which is really critical. Consider, as executor, you need the will to be able to gain access to the safe deposit box that has the will inside of it to give you access that you can't get access to until you have the will. It's like locking your keys in the car. What do you do then? If the will's locked inside the safe deposit box, or you suspect the will might be locked inside the safe deposit box, you can get an order from the probate court to drill the safe deposit box, to open up the safe deposit box. And it may or may not be physical drilling. There may be a way that the bank can do it without actual destruction of the door to the box. But in any event, you're going to need a court order to get inside there. These are all matters that you can sort of sort with the attorney during the consultation. But beyond the estate planning documents, if there is a death certificate, that's another item you want to bring with you. If you don't have a death certificate yet, a copy of the obituary is very useful. Any notices for the funeral, those sorts of things. We have been able to open estates previously where we've got a situation where the death certificate is hung up for an administrative reason, no fault of the family, but we've been able to get the estate open with the court by showing an obituary, a notice in the paper, funeral announcement, those kinds of things. Once the death certificate comes in, you file that with the court to update the record. So you can't go forever without it. But if you've got the death certificate, bring it. If you don't have it, let the attorney know that you're still waiting on that. The third kind of documents, with the estate planning documents, and there's the death certificate. The third, I mentioned before when we were talking about identifying the decedent, making sure that you've got the name right. These are court documents. And so these could be things like marriage licenses, divorce decrees. Very often people's last names change throughout their lives because of marriage and divorce. You may need to be able to document those things. Social security cards and passports, driver's license, state IDs, they establish identity. Sometimes you need more information about why the last name is what it is and how it got to be that way. In addition to those court documents that can impact the way that someone is identified, court documents can also, from time to time, affect what the distribution is going to be. When there is, for example, a prenuptial agreement, that's not necessarily a court document, but sometimes that has come into play in a divorce decree, those sorts of things. So in addition to the court documents, think prenups, those kinds of things, or postnups. So those are agreements about property that couples make either before they're married, a prenuptial agreement, or a post-nuptial agreement they make after the marriage has started. And those are binding, so you need to know what they are so that if there's a conflict between those settlement documents, the property distribution documents, and the property distribution documents like the will or the trust, you need to know that, and that's something for the attorney to sort out. How are those going to interact? So those are the things that you need to do document-wise. So to organize your thoughts about the documents, three broad categories: estate planning documents. Grab everything you see and let the attorney sort it out. Sometimes it's hard to tell which are originals, which are actually wills or trust versus powers of attorney. Just bring it, let the attorney sort that out. Second, death certificates, something establishing the date of death, and that sometimes you'll rely on those funeral announcements or obituaries. Those can be useful when the death certificate is delayed. Third, the court documents and prenuptial, postnuptial agreements, those sorts of things that govern the distribution of property. One thing I forgot to mention up to this point is also if there are businesses involved, LLCs or corporations, you're going to want to look for the documents that establish those businesses. And we're talking about the formation documents. We're also talking about operating agreements, any share agreements illustrating who's got what percentage, and really key with the operating agreements and bylaws, what happens upon the death of members of the company or owners of the corporation, because those can impact how distribution goes. Again, those are the kinds of things you give them to the lawyer, let the lawyer kind of sort them out and let you know what the next best course is. When there's a business involved, that can cause a lot of stress. Don't worry about it. It's all going to be handled either by the will or succession within the business documents. And so It's all going to come out in the wash. Don't worry if there's a business. It's just another level that you need to pay attention to. Again, turn that over to the attorney to work through those things. So if you're keeping score, that's 3 categories we've talked about with 3 subcategories in each. We've talked about people. That's the first category. That's being able to identify accurately the deceased person, the family members, and also who the beneficiaries are, whether it's a will or a trust. Second category is assets, and those assets might be financial accounts with brokerage houses, banks, credit unions, those sorts of things. Could be insurance policies, whatever it may be. So those are accounts. Real estate, so you're going to look for deeds there. And if you don't have deeds, just remember, hey, they've got a place in Destin. We need to pay attention to that. And then third, the tangible personal property. Those are all the things that don't have really readily accessible title. So that's the artwork in the house, the china, the silverware, the furniture, all those kinds of things. And that can include cars and even precious metals, which can be significant in value, but again, don't have a title certificate most of the time. Third category are documents. Those are the documents that you're hunting that are going to be important to administering the estate. And the documents fall into the estate planning documents. That's the will, the trust, but gather up powers of attorney and healthcare directives, even though they're no longer effective sometimes, it's hard to tell which is which. So again, documents, estate planning documents, take a broad approach there to look at what you got there. Second, death certificates, some proof of the date of death. So death certificates sometimes as a backup, obituaries or funeral notices. Third, there are the documents that may affect the distribution of property. And those can be court documents. Those can be prenups, postnups. Those can be operating agreements and bylaws in a corporate or company setting. So when you've got a business entity. So those are your 3 sets of 3 things to pay attention to be prepared to have a conversation about with the attorney. Again, if you're failing to fill out any of these categories, if you feel like I just don't have everything identified or located, don't delay the consultation with the attorney because of that. The attorney's there to help you sort of organize your thoughts and give you some guidance as to what's important to follow up on first, what things can kind of wait. Some things that you may think are going to be important turn out not to be just because of the way the law is structured and how things actually go. Remember, you don't have a lot of experience administering estates, and why would you? This is kind of an unusual situation. It's stressful. There may be a lot of grieving going on with the family and yourself. So give yourself a break. And I would encourage you to look to the attorney as some support and guidance. I would like to also tell you right up front that the court process, the probate process, is not smooth, and a lot of times it's not predictable. These courts have high volumes of cases, at least in my area. They've got high volumes of cases, and there's a lot going on at these courts, and sometimes cases can bog down, a lot of times for good reasons that may not be apparent. Sometimes they're bogged down and you don't really know why. These clerks are doing their level best to get these cases through the system and in front of the judges, who are also doing their level best to do a good job administering efficiently the probate process. But I would encourage you, it's really helpful to have an attorney so that when you get frustrated at the slow pace that might occur in the processing of these cases, you've got somebody to yell at who's not the clerk, because the last thing that a clerk needs is somebody calling them up and yelling about why this is delayed or that is that, or complaining. That can be detrimental also to the handling of your case. So let the attorney be your buffer. We follow up with the courts all the time and try and do it in a respectful manner so that it doesn't interfere with the administration of the cases. Just to keep in mind that it's not as smooth as we would hope it would be a lot of times. The other thing to mention is that this is not the time to speak ill of the dead, but as you're going through this process, this is an appropriate time to take a look and some consideration to your own planning and kind of look at what you're going through to administer this estate. If it's an estate without a will and you're just doing administration under the code sections that govern that in your state, or whether you're using a will, in which case you're still going through that court process, this is a good time to take a look at what you've got in place and sort of think, is this what I want for the people who are going to be my agent, my personal representative, my executor or successor trustee? Am I setting it up for them? Is this a great experience, or can I improve on it for them? So to me, it always comes back to planning, good planning, and that means good organization of the assets, where they are, how to find them, and the estate planning documents, so that your folks aren't left just at sea trying to figure out what's going on, and they've got a good roadmap of what to do. This is where trusts really shine over wills, because there's just less administrative tasks that involve other people, third parties like the court. With the trust, it's all sort of self-contained, and you still need to do some administrative work, but the administrative work is more internal, I would say, than external, and you're not waiting on other people or possible delays in another system. It's really up to you to do it. In particular, if you've got real estate in more than one state, for example, if it's a will or there's no will at all, but if it's not a trust, there's going to be a probate process in each state where real estate is owned to be able to transfer that real estate after somebody passes away. And a trust, you got one place that can own the properties in multiple states and no probate anywhere. So it's just can solve a lot of problems. Again, not the time to speak ill of the dead, but the time maybe to consider whether or not you've set it up to the best advantage of the folks who are going to be performing these tasks for you. Most executors and personal representatives are entitled to a fee. From time to time, people won't take it. If they're the sole beneficiary, a lot of times there's no need to take it. But I would encourage you, if you've ever gone through this, administering somebody's estate, or had watched a loved one go through this, it is a lot of work. And I would encourage you that executor fees are well earned. If you are an executor or a personal representative going through this and you're entitled to a fee, you should not feel the least bit shy about taking that fee, because it's a lot of hard work and you've earned it. You shouldn't feel funny about that at all. So that's my conversation in this episode about being prepared to consult with an attorney as a great support system to help walk you through the administration of a loved one's estate. If you have questions, if things we've talked about today spark some questions that weren't entirely answered, or you want to consult on your specific situation, go to my website. It's letstalkestateplanning.com. It's the same name as the podcast, letstalkestateplanning.com. There's a contact form there, our phone number. If you're in Georgia, I'd be happy to set up a consultation and we can talk about the specifics of your case and get you on the way to feeling more secure in what you're doing and not worrying a lot about it. In addition, I do estate planning workshops a couple times a month. There's no charge for those. And if you're in the Atlanta area, we would love to have you stop by and see that. I've also got a recorded version that's available on the website. My office is filled with terrific staff, a wonderful team that is knowledgeable and friendly and can give you a lot of good information. But if you got a question, shoot it to us, and I would love to meet with you if you've got a specific situation you want to discuss. My name is Jim Miskell. I've been practicing law for more than 30 years in the state of Georgia, and it's my dream that everyone gets their estate planning done so that families have less to fight about when grief and transition occur. I appreciate you spending some time with us for this really important information today. Have a great one. We'll see you next time.